All rise.
Be seated. Well, if you were here for our first argument this morning, you'll understand that we've had a panel change for the good. We have Justice Doss joining us.
It's the best introduction I've ever had.
The next case on the docket is cause numbers 723, 383, and 384 CR. Yocelin, Perez, Jaimes versus the state of Texas. What says the appellant? Good morning, Mr. Bennett. And what says the state? Okay. Good morning, Mr. Owen. Each side will have 20 minutes for argument, and the appellant has a 5-minute rebuttal. Any questions before we get started? Okay. Mr. Bennett, if you're ready. And we had a little trouble with the microphones this morning. You might make sure that it's working and we can hear you.
Okay. Is that better? Yes.
Yes. Yeah, you may need to turn that around just a little bit. I believe there's students in the other room that they may not be able to hear.
Of course. If I'm too loud, please.
Yeah, I don't think you're too loud. Go ahead.
Thanks. Today, with the court's permission, I'm going to refer to my client as Ms. Perez, as was done in the trial court, because Perez Jaimes is such a mouthful that it tends to distract from things. First off, since it applies to all three issues, throughout its brief, the state claims Ms. Perez confessed to this crime. But as the video recording shows of her interview with the detective, she doesn't confess at all. This woman is virtually always been in special education. She may be IDD, that was what her own sister testified. And she, to the sheriff's or the investigator's questions, she kind of gives little nods and Did she understand it, or is she just saying, I see what you're saying? Or is it a confession? We don't know.
Did the interrogation tape come into evidence?
I believe so, yes, Your Honor.
So the jury got a chance to look at her responses and decide for themselves whether what she was doing was either a head nod or an acknowledgement?
Yes, but to describe it as a confession is reaching, I think. I mean, if you've seen the movie My Cousin Vinny, Vinny's cousin at the start is accused of shooting a convenience store clerk. And he says, I shot the clerk. And the prosecutor describes that at the trial as a confession, because we know it wasn't. But Ms. Perez's little nods and quiet little non-committal, that's not a confession. According to the case law cited in the reply brief, a statement is not a confession unless the accused, quote, discloses the circumstances of the act or the share and participation which she had in it, unquote.
Could it come as some evidence?
Like what?
Could it come as some evidence?
I suppose it,
It rises to more than a mere scintilla. Would you agree on that?
no, because it doesn't show that she asserted that she did this act. It just says, Is she saying, I understand what the investigator is saying? Or is she just trying to parrot, to satisfy the investigator, asking her all these horrible questions? That said, with the court's permission, I'd like to start with issues 2 and 3 and come back to 1. Ms. Perez's trial attorney tried to cross-examine the investigator about what investigation he'd done into the impending trial of the complainant's sister. The prosecutor said the complainant loves her sister so much. And this was another trial in 27 days from the investigations, from the interview she had with the investigator, that Ms. Perez had brought domestic violence charges against the complainant's sister. The possibility that the complainant was fabricating her allegations is, I won't say enormous, but it's certainly substantial.
Well, weren't those allegations about something that happened more than 2 years prior to the case that was being investigated?
I wouldn't think so. I don't know the exact dates, Your Honor. I'm not prepared to answer that.
I think I read in the record where it was, those allegations were made like in 2019.
Could have been, yes.
And so this case was tried, when, in 2023?
Yes, but we're asking what the proposed questions were about were whether this investigator had looked into this other case and whether he'd done anything with these allegations. He would have said no, but at least he would have acknowledged that there's a case like this and there's the possibility that the complainant is fabricating these allegations because there was no physical evidence, so it was just one word against another, one person's word against another.
The state argues in its brief it didn't come in under 401 or maybe even 403. Do you recall what objection was actually posed?
That it was irrelevant.
Okay, just 401.
Yes.
Okay.
But when it came up later, when the defense attorney was trying to question the complainant's sister, it was excluded as being attenuated. And attenuation can apply to physical evidence, maybe to spoken evidence too, but that's a constitutional objection. And
Well, isn't in the context, could attenuation be relevance?
I don't see how. The trial of the complainant's sister...
Are not relevant.
Beg pardon?
I'm sorry, not relevant.
I don't see how. It certainly impacted whether the complainant fabricated her allegations, and that was the entire defensive theory. So, the state then says defense counsel's questions might have had some remote bearing on the matter at hand, but that's all we need, because this court said in August, the rules of evidence, quote, favor the admission of all logically relevant evidence for the jury's consideration, unquote. And that would seem to include something with even a remote bearing on the matter at hand. As Alford v. United States says, which he cited in the brief, cross-examination is necessarily exploratory because counsel can't know in advance what the witness will testify. So you don't have to say, oh, I think he'll say this, and they'll be relevant for that. It's exploratory. You get to do it anyway, even though you don't have all the answers because the witness has not given all the answers. Turning to issue 1. The issue isn't whether the jury was given legally unsound instructions on which the guilty verdicts rest. It did. The state brief admits it. The issue isn't whether the question was properly preserved. It was. The question is whether the legally incorrect instruction caused some harm, particularly because the prosecutor emphasized and re-urged the harm both at voir dire and in the closing argument. Now, I'm not accusing any prosecutor of bad faith. Unfortunately, most defense attorneys don't recognize or object to situations in which the culpable mental state is not limited, so I can't fault the prosecutor for not knowing either. But the harm remains. Unlike that of most offenses, indecency with a child requires two sets of intent. Intent to commit, or intentionally or knowingly doing the act, and intentionally or knowingly doing it, or intentionally I should say, with a sexual gratification in mind. Therefore, a correct instruction in this sort of case is vital. But here the instruction said, and the prosecutor said twice, oh no, you can focus on the result of this offense. You can't. As to quote a case cited in the briefs, quote, a nature of conduct crime is criminalized because of the nature of the act itself is unlawful, regardless of any result that might occur. Also, as noted in the briefs, in a sexual harassment case filed by a lady PE teacher, a lady justice at the Texas Supreme Court wrote the majority opinion saying, quote, a brief bottom grabbing by a same-sex coworker, unquote, is not necessarily a sexual act. It could be, it might not be. And here, the state's case that that Ms. Perez acted sexually was nowhere near a slam dunk. The complainant said, oh yeah, she and I like to horse around and play being professional wrestlers. She said she was a lifelong fan of somebody called A.J. Lee. The little I know of wrestling, I don't know apparently she's a lady wrestler. But that's a brief bottom grabbing. Is it sexual? Do we know? And the jury charge said, you can say that because she got off on it, supposedly, oh, that's enough to satisfy, that's enough for you to convict. It isn't. It's a nature of conduct offense. And like it or not, what the complainant describes is what happens in professional wrestling. Any 12-year-old who's watched it knows that. Probably happens in amateur, I don't know, amateur wrestling. But even a 12-year-old who's watched it knows that even a 4-year-old is expected to use some common sense, like not running out into traffic.
How would you propose that this, and maybe you've got cases that support this, how would you propose that the state be required to satisfy the sexual arousal portion of the elements under a nature of conduct offense? We can't obviously get in the mind of the defendant. How else would we do that?
I would think it's a question of credibility, of which do you believe? But with all due respect, Judge Joss, this is the state's problem, not mine. This is what the legislature has said, and
yeah, but at some point, somebody on this court's going to have to go back and draft an opinion, and so I'm trying to figure out, can you help us out on where you think you would draw the line if you got a chance?
Granted, but not my problem. Sorry, I don't mean to be flippant.
I understand.
But if someone who's underage, even someone who's underage, willingly engages in even play wrestling, and it seems like every high school and junior high has a boys and girls wrestling team, separate presumably, that kid has to expect that he or she is going to be touched in all sorts of places, roughly and perhaps painfully. That's the nature of it. Have you ever seen somebody say they want to work with children, they want to work with babies, they want to be an au pair, nanny, tending to babies, but they don't want to be thrown up on or urinated on? Sorry, it's going to happen. That's what the job is. And if a girl wants to, a girl or a woman doesn't want her breast touched, then she shouldn't go into wrestling, God knows, because that's what's going to happen. And she can't claim later that she was traumatized by this. That's precisely what happened here. Ms. Perez was said to have touched her breasts. She didn't like it, but she willingly engaged in this play wrestling. Now,
weren't there other allegations?
yes, ma'am. That's what I was getting to.
Okay. It wasn't just
No.
restricted to
No.
wrestling.
No.
She was how old at the time?
The child was between 12 and 17, I believe. Yeah, on at least one occasion, the complainant says, Ms. Perez was hugging her from behind and grabbed or pinched and bruised her breast. And she said Ms. Perez tried to put her hand up her shorts and touch her vagina. Okay. That is sufficient to sustain the conviction. So I didn't raise insufficient evidence here. But along with that, here the evidence is viewed in the light not the light most favorable to the verdict, but the light most favorable to the requested instruction. And so, do we discard what she said? I don't know, but it's less so. It has less impact because we have to look at it in the light most favorable to the instruction that was easily properly preserved, that you cannot have the result of the conduct. It is irrelevant. The state then says, well, the application paragraph cured it, and there was no possible motive other than sexual gratification. But the application paragraph doesn't give you any further definitions of intentionally or knowingly either. It says if you find Ms. Perez on such and such a date that she did then and there with intent to arouse and gratify the sexual desire of the defendant, intentionally or knowingly engage in sexual conduct with the complainant, a child younger than 17 years of age, by touching the breast of the child, then you will find the defendant guilty of indecency. How does that ameliorate definitions that are earlier that say this is what intentionally means? Intent means that you can convict if you just found she got sexual gratification for it. You can't. But the state also hammered at two parts of the trial that that was correct, and it wasn't. The erroneous instruction, when combined with the state's repetitions of this erroneous argument, forms some degree of harm. We can argue about how harmful it is, but it was harmful to some degree. Not theoretical, actual harm. And as I say, the evidence is viewed in the light most favorable to the requested instruction. Now, last point, I don't have much time, but the question posed in the reply brief has yet to be answered. Will the state admit either that harm was caused or that its comments at voir dire and in closing argument on the result of the conduct were utterly ineffectual and the jury couldn't have listened to them?
Well, to be fair, there was no objection made during the opening, right?
During opening, no.
Okay.
Nor in closing argument, but I've read case law, I'm afraid I can't quote you a name or a citation, but that such an objection would have looked petty to the jurors, it would have looked obstreperous because it comported with the instructions. So can you really object to that when the instructions say that's argument can be anything in the instructions is...
Well, sometimes counsel may have to be vocal about...
Granted, but in this case it wouldn't have been sustained, I imagine, because the instructions said this is what you can convict on. And
it would have been preserved.
But we're not raising the improper argument. We're just noting it as part of the harm. But will the state say that there is harm? Or will the state say that its prosecutor was ineffectual and nobody listened to it? The state hasn't answered that. I think it should answer that today. If the court has any questions, I'll be delighted to answer them.
Further questions? Yeah. Further questions?
Thank you all very much.
Thank you.
May it please the court.
Mr. Owen?
By these appeals, the appellant is raising three complaints. The first is the use of the full statutory definitions of the culpable mental states intentionally and knowingly. And by the second and third, she's complaining about the denial of cross-examination of the investigating officer about a case or a possible motive, I guess, that the complainant in our case had to bring these charges, to fabricate the charges. The third issue is what he sees as the constitutional dimension of the denial of the cross-examination. So I'll address those in turn. Now, Mr. Bennett is correct. The jury charge should have been more narrowly tailored in the abstract definition of intentional knowingly to nature of conduct rather than result of conduct. Normally, we don't think that we're going to go wrong by just tracking language out of the statute. And this is unfortunately kind of a common mistake that is made in these charges. But the fundamental question here is, could the jury have been misled by the instruction? If I'm understanding Mr. Bennett's argument, is that the jury could have believed that it could have convicted if the evidence showed that the appellant had some intent other than sexual gratification, but nevertheless achieved sexual gratification in touching the breast of the victim. But that's belied by the court's instructions. The first paragraph of the jury charge set out the substantive law relating to indecency with a child. It states exactly what the state had to prove. And then the application paragraph also limited the specific intent of the state to show that the appellant had the specific intent to arouse and gratify her sexual desire in touching the breast of the victim.
If there's a conflict in the jury verdict, though, as to what the instructions are, or a conflict in the instructions, how are we supposed to know which one the jury followed?
Well,
I mean, on the one hand, the appellant's saying, well, they followed the wrong instruction and that's harm. And on the other hand, you're saying, well, other places in the jury verdict or in the verdict form had the correct instruction, so they must have followed that. How do we know?
Well, I would cite to the court one case that we didn't cite on the state's brief. It's Vasquez versus State, 389 Southwest 3rd, 361 at page 367. That's a Court of Criminal Appeals case out of 2012.
And you say that is cited or is not cited?
It's
in your
not
brief?
cited.
It's not cited?
Yes.
Would you give us that one more time?
Yes, it's 389 Southwest 3rd, 361. The reference is to page 367, Court of Criminal Appeals case out of 2012. And there the court was highlighting the importance of the application paragraph in a charge as being the heart and soul of the jury charge. And so I think that sort of answers your question. I believe, Justice Dawson, that what at least a reviewing court ought to look at is the application paragraph. What that instructs the jury on on whether the jury should convict, the circumstances on which the jury should either convict or acquit.
Did that case involve alleged harm under 44, or do you know what the issue was there? If the appellate court said that it wasn't harmful because of the application paragraph, or?
Yes, I think so. I can't remember the specific facts involved in the case. There's never been a case that I found, at least, where the jury is accurately instructed on the substantive law in the application paragraph, well, also in the forepart of the jury instructions and then the application part. There's never been a case that I've found where the court had found reversible error. I think that probably in the state's brief, the cases that probably have the closest analogy are the Smith and the Jimenez case. Also, it's notable in this regard that the appellant has not challenged the sufficiency of the evidence. That would seem to subsume an acceptance of the state's evidence to prove that the sufficiency of the evidence to show the appellant's specific intent to arouse or gratify her sexual desire in making the touching. And in that regard also, there's no way that the jury could have been misled from the evidence itself. Early on in the evidence, it showed it was developed that the victim and the appellant, their interaction was that the appellant would sound out the receptiveness of the 12-year-old victim as to any being physical. Would you ever want to kiss me, or do you like me romantically, that sort of thing. Throughout a 5-year period, there's a continued pattern of groping. And then she testified that there's a ton of such incidents on the couch. She touched the breast with such force as to cause bruising. The cases, particularly the McKenzie and Bazanas cases that we've cited, stand for the proposition that the specific intent to arouse or gratify sexual desire may be inferred from the defendant's conduct and remarks and the surrounding circumstances. So based upon the evidence that was presented, it's hard to fathom how the jury could not have been misled as to whether or not the state had proven that the appellants had the specific intent to arouse or gratify her sexual desire in touching the breast of the victim.
Yeah, but isn't it reasonable to think, wow, she touched the breast so hard to cause bruising, that could have been related to wrestling instead of some sort of sexual gratification?
Yes, I'm sorry, I didn't quite.
That the breasts were touched so hard that it caused bruising is related to wrestling instead of some form of sexual gratification.
Well, there were some wrestling incidents, but the others are just totally in the context, like when she went up and grabbed the victim at the refrigerator when she was getting a beer for her father. That was clearly no wrestling involved there. Also, the victim, the appellant, in the confession or in the interview that Detective Eatley performed with her, she acknowledged that the victim did not like the touching, and she also acknowledged that she touched the breast of the victim with the intent of arousing her sexual desire or gratification. So I think
what would you say about the argument earlier about the alleged confession that took place with the investigator?
Well, it is what it is. Now, she didn't come out and just spill her guts on there, and the detective did kind of draw it out of her, but she acknowledges, if the court reviews the video, they'll see that she freely acknowledged, she affirmed at least, the questions that the detective was asking her, whether she did this, she was aroused, she was attracted to the victim, and she...
My understanding is that she said, and she nodded her head on occasion. Here's why I asked the question. I remember back in the late 80s, early 90s, we sent a number of businessmen over to negotiate deals in Japan, and a number of individuals in Japan who were answering questions would say yes, and yes didn't translate into yes meaning I agree with you. Yes was meaning I hear you. It seems like it could be ambiguous, that it could go both meaning yes and it could mean I hear what you're saying. I'm just curious what your position is.
Well, I think that if the court reviews the video, you'll see, in particular about the 36-minute mark, you'll see the incriminating acknowledgement of her her touching with the desire, the attempt to gratify. Even after she was arrested, the detective said, well, we've done wrong, and she agreed. So, it is what it is, and it certainly is enough to convince a jury, along with the victim's testimony, that the appellant was guilty of the offense. Now, with regard to the second and third issues, the appellant is asking the court to conduct a de novo review of the issues instead of looking at it from the perspective of an abuse of discretion. She sees a question of law in that because of the trial court's supposed invocation of the attenuation doctrine. Well, it's clear from the context of the court's remarks that it has nothing to do with the legal attenuation doctrine of whether or not illegally seized evidence can be considered because of the taint has been attenuated by other circumstances. So whatever review the court does on this, should be a deference to the trial court's decision. I mean, an abuse of discretion, as long as it's within the zone of reasonable disagreement. The court, of course, is the gatekeeper of whatever evidence should be allowed. The court is kind of the steward of the trial progression, and the court has a certain latitude there. And here, the court rightly perceived the inquiry that the appellant wanted to undergo as being basically a rabbit trail. It was entirely speculative. There was no suggestion anywhere that the victim had fabricated the accusation. In fact, the sister, when she testified in a defense case, the victim's sister, she testified she didn't even know about what had happened to our complainant in this case until September of 2021 when she made the outcry.
I think the only question that was being posed to the investigator was whether the investigator was aware of it and decided to look further into it, though, right?
Yeah, all he knew was the fact that there had been some sort of an altercation. By searching, he was looking for the address of the appellant, and he came across an IR, an incident report, where this case was brought up, the assault where the appellant was the victim, and the victim's sister was the defendant in that case.
Well, it almost seems that the detective made the decision on his own that the information was not relevant.
Right.
Shouldn't the jury have been able to make that determination?
Well, but there was no suggestion at all that there was any animus that the victim bore against the appellant because of that case. There was just no suggestion. All the cases that the appellant decided, there's been some extrinsic evidence of some reason to believe, at least.
Is it your position then that there has to be something else beyond the evidence itself? I mean, if an investigator's at a crime scene and decides not to photograph a certain item that's found at the crime scene, and they ask why, because that might relate to putting somebody else at the crime scene, that the defense attorney has to somehow put up another reason for why that object is relevant before
Well,
it
I think
comes
there have to be some sort of reasonable possibility, at least. And there was nothing in this case to suggest that.
Do the circumstances suggest, I mean, in and of themselves, that there was an outcry of sexual assault in this case less than 30 days before the trial of the sister was supposed to begin on other charges? Was that a way of trying to shut the complainant up, the defendant?
I don't think so. I mean, I just think it's just too remote, a possibility. At least that's what the court thought. It said, the words he used was attenuated, but the context being that there was no nexus, no tie suggested. In that case, incidentally, the sister, the complainant's sister, who is the defendant in this altercation with the appellant here, said that she had gotten pretrial diversion. The case was dismissed and expunged. And as you mentioned, Justice Parker, this was like, over 2 years before the trial started. The appellant could have made an offer of proof through the victim herself in this case as to whether or not she bore animus, but she didn't. Her only offer of proof was through the sister, who related that the case had been dismissed and expunged. But perhaps, at least most compellingly, the appellant at that point had already confessed. Now, the court we can decide whether or not that was truly a confession, but I think if the certainly the jury perceived it that way. I think if the court reviews the video, the court would be satisfied that she indeed acknowledged the legitimacy of the charge, and so, you know, it is what it is. I think that it'll show that she affirmed the accusation against her.
Is that how the state referred to the video during closing, as a confession?
In closing argument,
Yes.
I can't recall specifically, probably so, but I can't say for sure.
Well, one more question on the cross-examination and the confrontation issue. Do you recall, and I asked Mr. Bennett this a while ago, do you recall if the state posed, was it a relevance objection? Was it a 403 objection?
Well, it was tantamount to a relevance objection, yeah.
I think in your brief, you argued both 401 and 403, so I was trying to figure out what it was the court specifically addressed. And possible they addressed both, I'm just not sure, but.
Well, I think it's although it may not have been used those specific words, I think it comes down to it was grounded in relevance. Well, I imagine that some brilliant argument will come to me at 3 in the morning, but unless the court has any questions, I guess.
Anything further? Anything further? Okay, thank you very much.
Yes, thank you.
Mr. Bennett, you'll have a 5-minute rebuttal.
Thank you, Your Honor. May it please the court. Mr. Owen?
Mr. Bennett.
Justice Das, you asked a very interesting question. How do we know which one the jury chose? There's an older case which has been mentioned by the Court of Appeals. I don't know whether it's in published or unpublished cases, opinions, called Ex parte Drinkert, Drinkert, in which the Court of Criminal Appeals said, we are not willing to say the jury must have chosen the proper part of the charge, and not that it chose the improper charge. We're not willing to say that because it's not relevant, it's not proper. The standard here, of course, is egregious harm, is not egregious harm. This error might not meet egregious harm, but it doesn't have to. It was properly preserved, so all we have to do is show some harm. The state says no way the jury would have been misled. Under Alamo Heights versus Clark, that Texas Supreme Court case I mentioned, yes, it could, because a brief bottom grabbing is by a same-sex co-worker, as happened here, they said is not necessarily sexual. So also, there's no way the jury would have been misled if we believe the complainant's entire testimony about the bruising the breast or putting her hand up the complainant's shorts. If you believe that, maybe the jury wouldn't have been misled. But that's not the standard here. The standard here is viewing the evidence in the light most favorable to the instruction. And so, can we believe everything? I don't think so under that standard. If it's insufficient evidence that we're raising, yes, okay, it's the prism of the light most favorable to the verdict. Everything she said is true, deemed to be true under that standard. But here it's the reverse. So the application paragraph, it doesn't redefine, as I said before, it doesn't define intentionally or knowingly. It uses the prior definitions. How is that ameliorating the harm? It doesn't point to those definitions, but the jury has been instructed that intent in this case can be satisfied by the result of the occurrence. It can't. That's what the offense is for.
On that line, I know you're not appealing the factual sufficiency. However, should we take into account, or how does it go into account, the video and the other evidence to the harm analysis? Does it ameliorate some of the harm with the video and the other evidence that was admitted?
No, because it doesn't say it doesn't tell the jury that intent does not mean the result of the conduct. It just, the only definition was that it did. And as Mr. Owen and I agree, that was error. Mr. Owen hasn't questioned whether we preserved it. We did. So the harm particularly in the state saying, oh, you can convict based on the result of the conduct twice in two separate parts of the trial, I think harm is evident. It's clear. The state says the third issue is of its constitutional dimension, and in its brief, it implied that that wasn't what the objection said. But if I raise ineffective assistance of counsel, if at trial, the trial attorney said, Judge, I'm supposed to be here, my client is not being afforded effective assistance of counsel, and I'll cite you Texas Code of Criminal Procedure 1.051, I believe it is, then on appeal, are you not entitled to look at it in the Strickland sort of analysis? He only cited state law, but I think Strickland is going to have to come into it, because Strickland is the seminal case for that sort of argument. But are you restricted to just 1.051 because that's all he raised? I don't think that can be done. If any other of you has any questions, I'll be happy to answer them. No? Thank you all very much.
Thank you. The case is submitted, and we appreciate the fact that y'all came down from Amarillo all the way to Lubbock to hear your case when you could have just walked across the street. Or it was a pleasure having you. Thank you so much.
Thank you.